Welcome to the deep dive. Today, we're looking at a really interesting legal question that came out of a 2011 case, Royal Bank of Canada versus Rastogi.
Yeah, this one's fascinating. It's all about whether a bank can just, freeze your money without a court order.
Exactly. And not just at their own bank, but potentially across different banks or affiliates just because they claim you owe them something.
The situation involved an RBC employee, Ankur Rastogi. RBC accused him of using, well, they said a loophole in their online banking system.
A loophole involving the employee exchange rate.
Right. They claimed he used it for an arbitrage scheme and that RBC lost about $700,000 because of it.
Wow. Okay, so RBC's reaction was pretty strong then.
Oh, yeah. They didn't just freeze his regular RBC accounts. They also froze his investment accounts at RBC Direct Investing. That's their affiliate.
And didn't it involve another bank too? TD.
That's right. They effectively froze funds in a joint account he had at TD Bank as well. So our mission here is to unpack this. Does a bank really have the power to freeze funds so widely, just based on their own accusation?
Especially before any court has actually ruled on the accusation itself. We're focusing on those RBC Direct Investing and the TD accounts mainly, because the freezing of the main RBC accounts wasn't really the core issue on appeal.
Exactly. RBC froze everything related to him they could touch. Rastogi, though, he pushed back.
What was his argument?
He basically said, look, I used publicly available information, the bank's own published rates. He even claimed his trading activity wasn't some big secret at his branch.
So he felt he hadn't breached his employment contract or misused any confidential info?
Correct. And he didn't just defend, he counterclaimed. He wanted his money back, obviously, damages for the freeze being wrongful. And he also sued for wrongful dismissal, though, like you said, that dismissal part isn't our focus for this deep dive.
Okay, so he takes this to court. What specifically did he ask the court to do initially?
He brought a motion, basically asking a judge to order the release of the funds held by RBC Direct Investing and TD Bank.
And how did that first judge rule?
It was sort of a split decision. The motion judge said, okay, RBC can maybe hold on to the funds in its own accounts because of a potential set-off. If he owes them money, they can potentially keep it to cover the debt.
But on not the other accounts.
Right. The judge ordered RBC Direct and TD to release the funds they were holding. RBC wasn't happy about that part, so they appealed that decision regarding the RBC Direct and TD money.
This is where it gets into the nitty-gritty legal principles then. What did the Court of Appeal have to say?
Well, first, they restated something fundamental. The money in your bank account. It's technically a debt the bank owes to you.
Okay, that makes sense.
Yeah.
So how did RBC justify freezing the accounts at the other places?
Their argument hinged on unjust enrichment. They were saying Rastogi got money unfairly, and they claimed they could trace those alleged profits into the RBC Direct and TD accounts.
But just saying you can trace it doesn't automatically give you the right to seize it, does it?
Absolutely not. And the court was really clear on this. Having an arguable case that someone owes you money doesn't give you a superpower to just freeze their assets unilaterally.
So what would they have needed?
Normally, to freeze assets before a final judgment, you need a court order, specifically something called an interlocutory injunction. Think of it as a temporary freeze granted by a judge.
And RBC didn't ask for one of those?
Nope. And to get one, they would have to meet a specific legal test, show a strong case, prove they'd suffer harm that money couldn't fix later, and that the balance of convenience favored the freeze. They skipped that whole process.
What about the RBC Direct Investing connection? It's an affiliate owned by RBC. Does that matter?
Legally, the court said no. RBC and RBC Direct Investing are separate legal entities. Just because RBC owns RBC Direct doesn't mean RBC can treat RBC Direct's debts. The money owed to Rastogi as its own debt for set-off purposes. They're distinct.
Okay, separate companies. And the TD account. Why did TD freeze the funds there? Was RBC allowed to tell them to?
Not exactly. The court looked at the Bank Act, specifically Section 4372. This section basically says if a bank like TD gets dragged into a lawsuit over funds they hold, they're allowed to hold on to those funds until a court tells them what to do.
Ah, so it protects TD.
Yes, it protects TD from being sued later for releasing money that might belong to someone else. It doesn't give the plaintiff, in this case RBC, the right to order the freeze themselves. TD was just waiting for the court's direction.
So, wrapping this up, what was the final outcome from the Court of Appeal?
They essentially agreed with the first judge's decision about releasing the funds. They upheld the order for RBC Direct and TD to give Rastogi his money back. They slightly modified the order just to make it a formal judgment for Rastogi regarding those specific funds.
But did this mean RBC's whole case against him was over?
No, not at all. The court made a point of saying this decision was only about the pretrial freezing of those specific accounts. RBC's main claim that Rastogi was unjustly enriched could still proceed to a full trial to be decided later.
Right. So for you listening, what's the big takeaway here?
I think the key point is that, generally speaking, a bank can't just decide on its own to freeze your money held at other institutions or even at its own affiliates simply because it claims you owe it money.
They usually need to follow the proper legal steps, like getting that court-ordered injunction we talked about.
Exactly. Due process matters.
This case really shines a light on the legal protections we have for our bank accounts. It shows there are limits, real legal limits, on a bank's power to just lock up your funds without going through the courts first.
It definitely highlights that gap between thinking you have a claim to money and actually having the legal right to seize it before a judgment.
Which leaves us with a final thought to consider. What does it mean for individuals when large, powerful institutions can potentially restrict access to your essential funds based purely on allegations? It makes you wonder, are the current safeguards strong enough to prevent potential overreach before the legal facts are fully determined?
A really important question in today's financial world, something definitely worth thinking about.